Stuart Davidson from Boca Raton with my co-counsel on behalf of the plaintiff appellant Alan Serchay. I'd like to reserve 2 minutes for rebuttal if I may. Your Honors, the seminal question before the court is the following. Whether ordering that a statutorily required discount constitutes rate making if it has nothing to do with the rates being charged or the premiums that are calculated based on those rates. From that question, what we are asking the court to do primarily is to reverse the dismissal of the case on the grounds that Mr. Serchay was required to exhaust his administrative remedies under 627371, which based on its plain language only governs challenges to the rate charges, the rating plan, the rating system, and an underwriting rule.
I can understand why you would phrase the question that way, but I'm really troubled to determine how this doesn't have something to do with rate. What we're talking about here is a discount on the insurance premium that Mr. Serchay, and if he got that far, the other class members should have gotten but didn't get because State Farm didn't follow the statutory procedures, as they say.
Judge, the way I would, Your Honor, the way I would phrase it or frame it is this. Picture a pyramid that an architect comes before the OIR with a blueprint of how they are going to construct that pyramid. After the OIR approves that blueprint and the pyramid is constructed, which includes the rate base and how they are going to calculate those premiums based on actuarially provided calculations, then a capstone is placed on top of that pyramid that has certain automatically statutorily required discounts. And that's what we are arguing to the court, is that the OIR does not concern itself with whether or not the discount was actually applied to the case, but whether or not the rate itself was proper. And remember, Your Honor, Section 627031 of the Florida statutes explains what the whole policy and the purpose behind Chapter 627 is, which is so that the OIR governs excessive rates, inadequate rates, or unfairly discriminatory rates. Whether or not a statutory discount is placed on top of that pyramid is unrelated to that issue. And what I would bring to the court's attention, which we've cited in our papers and which State Farm inexplicably did not even address, are the two cases which have actually addressed the issue of whether simply applying a discount or a credit actually constitutes rate making, so that administrative exhaustion would be
one case that you one of the cases you rely on, I believe, is a workers' compensation case, and I don't see how that's going to help us here, because that talks about where you have to do an audit of the insured's business at the end of the year, and I know a little bit about workers' compensation, to determine whether they were charged the proper premium or not. So that's not even implicated here, I don't think.
It's not, Judge, and you're talking about the FCCI case, but the statements and the holdings of that case and its explanation of why the Elite 2 case from Judge Kavakovich in the Middle District, in our opinion, govern how this court should treat this case.
Are we bound by the Elite 2 decision? Absolutely
not, Your Honor, but it's a persuasive opinion in which Judge Kavakovich held that simply applying a credit, the question in Elite 2 was simply whether the plaintiff should have received this Florida contractor classification adjustment credit. It had nothing to do with the rates being charged or whether the rate base was excessive or inadequate or unfairly discriminatory. But then, if there was any doubt as to whether Elite 2 was good law and should be applied, in our opinion, that doubt was erased in February of this year when the second DCA held in FCCI that Elite 2 did not apply in that case because, this is a quote from FCCI, Elite 2 deals with the application of a credit in calculating the final insurance premium. It did not concern, quote, the actual basis for the calculation of the final premiums. And that's why the cases relied upon by State Farm are completely distinguishable.
The cases on that State Farm site are those applied 371 and said the plaintiff had alleged you hadn't complied with a statute of how you're going to create a rate. That's exactly what you're doing here today. You're saying basically you're supposed to have given us a discount. You're supposed to have notified us about the discount. You didn't do those things. You didn't comply with these two other statutes, and so therefore we should go to the Office of Insurance Regulation.
Your Honor, we disagree. All four cases relied upon by State Farm are factually and legally distinguishable in multiple ways. Every one of those cases, from Zimmerman to Gibbons to Rayum, all dealt with the rate-making process itself and whether the rates were excessive, unfair, or inadequate, or unfairly discriminatory. In Rayum, it was a paid-in-full discount that was applied that the OIR had approved, and the plaintiff in Rayum had actually alleged that they were being discriminated against. And that's what 627.031 says the OIR is supposed to look at. And the court in Rayum actually went further and said, if we get rid of this discount, then other insured's rates are going to rise.
From a practical standpoint, shouldn't we be looking at this deference to OIR broadly? Because what happens if you go to OIR? You walk in with the same claim and say something was done unfairly to my client. He's supposed to get this discount. OIR is going to have two choices. Either they're going to say, this isn't rate making, go back to circuit court. You can still come back to circuit court. Or they're going to say, you've come to the right place. What's your argument? Make your best case. And if you win, your client got what he asked for. If you lose, you get to go to the administrative appeal process or the DCA and say that they were wrong. You haven't lost anything by going to the OIR. You just don't get attorney's fees by going to the OIR.
The problem, Your Honor, is that 627.371, which, quite frankly, how Florida law evolved into a situation where the words may became shall, I'm not sure I can follow. However, the Florida law has evolved in a way such that if there's an administrative remedy, you got to go there. But the exhaustion requirements, where there is only primary exclusive jurisdiction with the OIR, is limited by the statute. And the statute does not govern statutorily required discounts. Just because, Your Honor, the OIR may have the ability to issue an opinion in the case doesn't necessarily mean that there's not concurrent jurisdiction with the circuit court.
Other than the right to seek 627, 736 fees in circuit court, what does your client lose by going to the OIR as opposed to circuit court? What does he lose?
He has the right in...
That's not my question. What remedy can he not get for the OIR that he could have gotten in the circuit court, besides attorney's fees?
Well, first of all, Your Honor, I think you meant 627.428 attorney's fees, not the PIP statute. But
I'm thinking PIP. Too many days in county court.
I understand that. But in our opinion, what he loses is the ability to represent a group of, which State Farm, I believe, represents nearly 1 million, insures nearly 1 million people in the state of Florida. The likelihood that an individual would come before a circuit court and on their own, or even go before the OIR and find an attorney to do that, I think is almost nil. That's what Rule 1.220 is created for.
We confronted a similar issue. You may not find it similar. Several years ago in a case involving Kraft Foods, and I'm afraid I don't have the site for you. But the premise was this. It involved a claim about a $3 rebate that the consumer might have been entitled to. And we observed that while, yes, it's very difficult for any one person to hire an attorney and follow this through to get their $3 rebate, the class action provisions of the Florida Rules of Civil Procedure did not encompass or did not contemplate that every single claim that somebody is unable to bring because of, the one person is not enough to do it, means you get to bring this as a class action. It's particularly problematic in this case where the legislature has set up an administrative procedure, and as Judge Gerber's question, I think, observed, we don't, the district courts of appeal don't deal with rate cases every day. In the utility area, thank God we don't deal with them at all. But this procedure is set up through an agency of the state of Florida, the executive branch, so there may even be a separation of powers problem here, to deal with that initially. And then as Judge Gerber correctly observed, if you're unhappy with the result, you don't even have to go to circuit court. You go right to the district court of appeal.
Judge, I understand that I'm out of my time, but
You're asking questions. You keep going.
But my response to that, and my response to Your Honor, is that just because the OIR may have the ability to deal with an issue doesn't mean that they have exclusive jurisdiction, which is governed by a strict statutory interpretation. And if the court, in our opinion, goes by a strict statutory interpretation of 627371, then this discount that applies on top of that pyramid would not be governed by that statute. And what we'd ask the court to do is reverse both the dismissal of the case below, as well as reverse the court's decision to deny its discovery to determine whether the functional equivalent of the confession of judgment doctrine applies.
We'll save some time for rebuttal. Counsel for Appellee.
May it please the court, Paul Regensdorf with John Chandler for State Farm. My job here today is to try to dispel the suggestion that we have been spewing smug Orwellian doublespeak.
Leave that out, okay? Let's talk about this case. First question out of the box, Mr. Regensdorf.
Yes,
why didn't you address FCCI in your answer brief?
I'm not sure it came to our attention. It was decided 3 days before, and 3 days before their brief. I don't recall. We certainly didn't not address it in the sense of ignoring it, meaning making a decision. Would I have liked to have discussed it? Absolutely. The second district really answers the question in the Kovacevic case in Elite 2. What FCCI says is that in Kovacevic's case, Judge Kovacevic's case, it was a question ultimately of what does the contract require. That's what she said. She says, because it's contract, I'm going to look at the contract, and then I'm going to apply whatever the contract says. Understandable. In FCCI, the court said, the second district said, this is not a contract. I can't look at the contract here. You can't look at this contract here. And with all due respect, you can't look at the statute here either. You can't look at the statute here because there is no discount in the statute. What it says in the statute, 627-0629, is everyone shall come up with a rate plan, and you shall file it. And you shall file it no later than February 28, 2003. And State Farm did, on February 27, 2003, file this document. This document is a complex document that not only has some numbers, so many cents per thousand or whatever, but it is a rate system. The statute, 627-371, gives to the OIR exclusive, not joint, not parallel, exclusive jurisdiction in the areas of rates charged, rating plans, rating systems, and underwriting rules. The debate in this case, boiled down to its essence, is two things. They don't like the notice that we gave, mandated by the state. They don't like the windstorm loss reduction rating plan survey. They don't want to do that. Okay, the problem with their argument at its base, when you understand the rating system, is that that was part of the whole rating system. It was approved, the form was approved by the OIR. We are not allowed to deviate from that. They don't like the system. Maybe at some time citizens accepted a Polaroid photograph of the type of roof. The requirement is that the rate be actuarially sound so that it's not too low to be price cutting, but not too high so that the homeowners get what they're entitled to in terms of savings because of any one of 5 or 10 different structural features. The state, we submitted this form to the state as part of our system. We're not going to pay to anybody who claims a hip roof. They're going to have to go get a survey. Now, interestingly enough, this survey that they don't like, of course, they could have gone to the OIR and participated in the rate-making, the rule-making process, or they could have joined any proceeding or filed their own and challenged what the OIR had specifically approved.
Could they have gone to the OIR and simply said, we're entitled to a discount and we didn't get it?
Absolutely, they could have. That's the whole issue, because they would have had to show why somehow our rate system, rate plan, rate charge was somehow incorrect or improperly assessed, but they didn't. So the two things they're challenging, the notice and the fact that we required them to do a survey and the state approved of that process, is somehow wrong. Well, they're challenging the very essence of the rate. They argue citizens does it by a photograph. I would point out to the court, 627.711, which was enacted in 2005, said now you have to give a particular type of notice, and we're going to require the type of notice. In 2007, 627.711 was amended. And what was it amended to provide? Now the state, recognizing the wisdom of what State Farm had been doing, and perhaps others, mandated that very type of survey of houses. so that the state would know through its regulatory process, OIR has got to make sure the rates are not too high and not too low. They've got to make a fair rate. So now they're going to require everybody to do exactly what they approved for State Farm. Exactly. And you know something? The proof in the pudding comes down to the consent order case that you have had given to you by counsel in a post-decision motion. It's in the record starting at page 189. Just like the understanding of the rate system and the fact that the things they complain about are critical components of the rate filing itself, the notice and the survey, the state-approved survey, so too is the consent order understandable, and you need to understand it. It is not a broad brush attack at State Farm. Mr. Serchay, were he to fall into a category, which he doesn't, because he didn't do the survey, were he to fall into a category, he would be in category A. There's 5 categories, A, B, C, D, E. You can read through them. But read them closely. The state, after dealing with State Farm for years on this process, from 2003 right on through today, on how we're going to adjust this process, they brought an investigation. And what did the consent order determine? Category A, number 1, you have to be an insurer who renewed between January 1 of 05 and June 30, because that was the glitch where they didn't like exactly the forms that were used. First of all, you have to fall into that category first. I don't know when his policy.
June 30th of 1 year.
05. 6-month period.
That's 6-month period.
6 months, that's point number 1.
Okay, and State Farm paid $120 million in rebates for that.
There are 5 categories. One is business, they don't fall into that. One is the building code discount, they don't fall into that.
For all
One is
5
renters.
categories.
Yeah, well, let me go on, because it's the next couple of points. First, it's just those 6 months. And you must have not gotten a discount in 05. Then you must have been a renewed customer in 06. If you aren't a renewed customer, and he was, then you would fall into category B. But we're still in category A.
Aren't you well behind the primary question, which is where does Mr. Serchay file this action in Circuit Court or OIR? That's a simple question we have to decide today, right?
Yes, sir. And my only point, perhaps I've gone way beyond it. The answer is there's only one place. There's no concurrent jurisdiction. State Farm versus Gibbons very clearly says you don't defer, you dismiss. There is no jurisdiction. The Lewis case talks about there's got to be some legitimate purpose for filing a lawsuit if you're going to get attorney's fees. This is an ultra vires, unrecognized, improper act in a court that has no jurisdiction. Your only jurisdiction is not to review OIR, because you can't do that. It is only to review the actions of Judge Green, who properly said, I have no jurisdiction.
All right, but we still need to talk about the attorney's fee issue, because that's before us. Okay. And assuming we agree with you hypothetically that he should have gone to OIR,
correct.
If there is evidence out there, you know, the smoking gun memo from State Farm CFO that says, because Mr. Davidson filed this lawsuit against us in circuit court and now we're in trouble about what we did with our rebates, we better ante up and enter a consent order. Is there any theory under which he could be entitled to attorney's fees for having brought this action?
Absolutely none. Because the first point is you must file an action in court. He filed an action in court, but whether he filed it here with no jurisdiction or Wyoming or France, it is not an action that under your Lewis case, which you were on a few months ago, that deals with, it must be an action with a legitimate purpose. There is no legitimate purpose for this thing that they filed in state court. That's the first thing. Second, you have to get a judgment. Well, I realize that the rules have softened to the point where you got to get something that does you some good, some sort of
a settlement will do.
Yes, of course. Yes. But, and this is where I get back to the consent order, because category A is very important. The only thing that they did in category A, the people that are homeowners in his potential arguable area, are you were in 05, you got no refund, you renewed in 06, you applied for and you were qualified to receive the discount. And it's not just hip roofs, it's all different types of discounts. So
which would involve the survey.
Which would have involved, absolutely correct. You had, in other words, the OIR again approved the process and said if in 06 you were again an insured, you had an applicable refund claim, you made it and you didn't get it, then you fall into category A. It's simply not Mr. Serchay. So it doesn't really matter what happened in the consent order, except that understanding it can put perhaps your minds at ease. Because step one, answer to your direct question, is there anything that he could have done with that smoking gun out there where the CFO says we've got to do something about Serchay because he's banging us down in Broward County? Absolutely nothing he could have done because he filed a nullity. It'd be like going out on the street with an Uncle Sam suit on and saying, State Farm is cheating me. Suddenly State Farm hears about it, they bring in the OIR investigation, or somebody hears about it, and as a result this guy gets a refund. Is he entitled to attorney's fees for doing that? No, of course not. Because standing out on the street corner, yelling and putting up a sign, State Farm's a bunch of crooks, doesn't do it. 627-428...
Well, let me suggest to you a scenario which didn't happen here, okay. and maybe this could lead to an attorney's fee, but I don't know about class action. We're not even close. If he'd gone to the OIR, right. and the OIR said, State Farm, you owe him a refund, went through all the procedure, and State Farm says, no, I'm not going to pay it, and then he goes into circuit court to enforce a district court of appeal somewhere.
There is no circuit court.
Yeah.
There is no place in the carefully constructed regulatory rate-making scheme for the circuit court. God bless them, they do wonderful work, but not in this area.
So the only thing OIR can do is put State Farm out of business?
No. Well, I'm sorry. Yes, there is a regulatory procedure. They can fine them. In this case...
And they force them to pay him the refund?
Well...
He's got to have some relief.
The answer in this case, that State Farm was given, I believe, 1 year, 90 days to start, 1 year to finish, and correct me if I don't have the dates wrong, in this consent order, which does not apply to him. And they said you got 1 year to finish it up to pay out $120 million. Your answer is if State Farm says no, I think at that point they have violated the order of the OIR. I cannot cite you a statute, Judge Poland. I would be shocked that the OIR, as the regulatory body, could not at that point begin some sort of an action to terminate their license or apply further penalties or whatever. I just can't imagine it. But the remedy in that situation is not to go to circuit court. It's not to go to Wyoming. It's not to go to France. It's to file the appropriate proceeding. That's what the statute would require. Now, it would not generate a claim for attorney's fees, respectfully, I don't think, because the proceeding would be an appeal to the First District Court of Appeal, I believe. Not that you can't get attorney's fees in an appellate court if you're otherwise within 627.428, but none of the things we've talked about place Mr. Serchay or the hypothetical plaintiff you're talking about into that situation, because the proceeding would have been in the OIR. Would be an interesting argument whether that would be a sufficient court proceeding with a sufficient judgment to fall into the statute, but I don't know of any case that says that. I can tell you this. I'm aware of absolutely no case anywhere that says the bringing of a proceeding in the wrong court, i.e. one that has no authority and no legal jurisdiction, that the bringing of that action, no matter what happens thereafter, constitutes the basis of a Florida statute 627.428, attorney's fees. Again, the Lewis case is different because that dealt with arbitration, but the proceeding was, the sentence said in the opinion, it's got to have a legitimate purpose. In that case, it was kind of a close question because the timing of the arbitration versus the bringing of the action was sort of reversed. And
we're going to have to ask you to wrap up because we've gone way over the time.
I consider myself wrapped. My papers are over here. All I need to do is move my corporal sense over there. Okay. If there are no further questions, I think hopefully we have responded to your honors. If there's any additional information we can supply you, of course, we'll be happy to do so. We think the decision should be affirmed on all counts.
Mr. Davidson, rebuttal.
Thanks, Judge.
It says 15 seconds, but we'll give you a minute or two.
Thanks, Judge. The attempt to distinguish Elite 2 by Mr. Rexendorf, with all due respect, was erroneous because the Elite 2 case, the court did hold that the reason we don't have to get into the rate-making process is because we have to look at the contract. And Judge May, you held in, you were on the panel in the Lutz case, reversing Judge Gerber, in which you held that
he doesn't hold that against me.
Yeah, flattery will get you everywhere.
Where you held that a cause of action for breach of contract does lie under Chapter 627 if you can tie a specific statutory violation to the contract, and that's exactly what we brought here. So just as the plaintiff in Elite 2 was and it's not evident from the decision itself, was able to tie the failure to provide a contractor's credit to the insurance contract and brought a bad faith claim, well, that's one type of claim that they can bring in circuit court, but so too can you bring a common law breach of contract claim for a statutory violation.
Lutz didn't involve 371.
I'm sorry?
Lutz did not involve 627, 371.
No, but it dealt with Chapter 627, and
But here what we're talking about in this case
I understand.
is whether 627, 371 requires your client to go to the OIR. That's what we're talking about in this case.
And Judge, it's our opinion that the Elite 2 and the FCCI's case, which essentially validated Elite 2, would govern this, because none of the other cases cited by the appellee have anything to do with this case. The Gibbons case dealt with a challenge to the rate base itself. The Zimmerman case dealt with a challenge to the entire validity of the rate-making process and whether you could increase a rate due to private arbitration. They haven't cited one case that's on point and to this court, and it's our opinion that the Elite 2 case is directly on point, and a Florida court and a Florida appeals court has validated that opinion. So,
just so I'm clear, because I asked you this question on the front end, I know you ran out of time, but your best response to the question of what does your client lose by having to go to OIR is that because he's not going to be able to get an attorney's fee, he may have difficulty getting an attorney to represent him there. That's your best response to that question.
That's correct, Judge, and I believe that the case law is evolving in this country so that the right to bring a class action is actually starting to sway courts to understand that people are not going to bring a $3 or a $100 discount claim absent that ability. And just to be clear, we are not seeking class action fees based on a common fund of the $120 million consent judgment. We are just seeking fees under 627-428. And Judge Poland, you held in the Lewis case that as long as you can show that the lawsuit was a necessary catalyst for the payment, that you're entitled to fees under that statute.
But Mr. Serchay hasn't gotten a dime. He's never gone to OIR or gotten his discount. So nothing has been created for him.
Maybe, perhaps not for Mr. Serchay, but he filed a putative class action in this case, and I think the magnitude of this case, the magnitude of the consent judgment, the incredible circumstantial evidence that Mr. Serchay's case caused or was related to in the Unterlach case, is the language that Judge May, you were on the panel for, was related to that. I think that distinguishes this from almost any other case, is that it's so compelling. I'd ask the court to think to themselves, what if Mr. Serchay's case did cause $120 million to be paid to State Farm Insurance? I think that alone would at least, at a minimum, allow this court to remand so that we can take the limited discovery that we're seeking. That's what the court in Avila did. That's what the court in Essex Builders did, just to make a record so that everybody can be on the same page as to whether 428 applies.
The same result could have been had, $120 million consent order, if Mr. Serchay filed with the OIR.
That's possible. We'll never know. That's it, Judge. Thank you very much.
Thank you.
Thank
You
you.
all